What is a DWI with an open container? It is an offense here in the state of Texas. And the law says that if it's shown on the trial of an offense under this section being 4904 of the Texas Penal Code, the law for DWI, that at the time of the offense, that the person operating the motor vehicle had a open container of alcohol in their immediate possession, then it turns it into a Class B, and the minimum term of confinement is 6 days. Okay. It used to be 3 days if you didn't have the open container. If you have an open container, the new minimum confinement time is 6 days. This is part of the reason it's not 0 to 180 days like most Class Bs is because basically political pressure, Mothers Against Drunk Driving, things like that, forcing there to be jail time as a consequence to try to dissuade people from drinking and driving. That, in my opinion, has had absolutely no effect on dissuading people from drinking and driving. Biggest change I've seen over the years is Uber. Even that, it's not, it doesn't prevent things entirely from happening. But more so, from a criminal defense perspective, it doesn't just prevent people, who do drive while intoxicated. We have plenty of cases where people have had 1, 2 drinks. They're not intoxicated. It's legal to drive in Texas if you're over 21 and you are not intoxicated, but you have had some alcohol. There is no law that says you can't drink and drive. There's only a law that says you can't drive while intoxicated. But if you have that open container in the car with you, they increase the punishment range. That's what a DWI with an open container is. So what is the definition of an open container? An open container means a bottle, a can, or some other receptacle that contains any amount of alcoholic beverage and that is open, that has been opened, or that has a broken seal, or the contents of which have been partially removed. So if you go buy a daiquiri at a drive-through, they put that tape or seal over the top. That is to try to be in compliance with this law. I'm not sure that's going to save you, but this would also cover like a wine bottle. You bring it to a friend's house, you uncork it, you drink some, you cork it back up, you bring it back home. That's an open container. So there are, there's this law that says you can't have an open container, but you can have it like in the trunk, okay? Because it's not accessible to you in the driver's seat. It's not in your immediate possession if it's back in the trunk. If you have like a Tahoe or a Suburban, they consider the back part of that all the way past the third row seating. They're going to consider that the trunk, so you can have it back there. So this is always my advice. If you're going to a party, you have any kind of alcohol that you've had, let's say you have a fifth of vodka that you took a couple shots out of last weekend, you want to take it to your friend's house, on your way over there, put it in the trunk, and then you can bring it out when you get to your friend's house. So how do we challenge a DWI with an open container case? Well, the first thing we do really with every criminal case is the police have to have reasonable suspicion to make any kind of contact with you. So if they don't have a good traffic stop, if they don't have a reason for pulling you over, then all the evidence past that is going to get dismissed. It's going to get suppressed under what's called the fruit of the poisonous tree doctrine. And all the evidence of like alcohol content, any of your statements, none of that's going to be available for the prosecution. It's going to result in your case getting dismissed. Same thing for probable cause for the search. In order for them to add on this enhancement, they're going to have to find that open container. Did they have a reason to search? If they made an arrest for DWI, typically a inventory of the vehicle, if nobody else can drive it, or a search incident to arrest is going to be able to find anything in your immediate area. And then that's going to probably qualify as immediate possession. Normally, the open container gets found when they're at the vehicle door. So if we can find a problem with reasonable suspicion, they can never get to the vehicle door. And that's where we win a lot of these cases. We're going to have to look too at the placement of the container. Like I said, if you've got a Tahoe or a Suburban, something like that, and it's all the way in the back, that's not an open container for this offense. It's not an open container at all, even though it is in fact a container and it might be open. It's not an open container under the law because it's not in the passenger compartment. And then finally, we're going to challenge the intoxication level just in general. Did the officer perform the standardized field sobriety tests correctly? Did he instruct you correctly? When you were doing the test, did he pick an area that was dry, flat, no pebbles, rocks? Did he let you take off your shoes? There's 100 different things that we go into on that. Check out our videos on not public intoxication, but on the standardized field sobriety tests and things like that. And finally, what is the punishment for a DWI with an open container? It's a Class B misdemeanor. That means it's 6 days jail minimum, up to a $2,000 fine, up to 180 days in jail. The regular range for the Class B, again, is 0 to 180, but because of that open container, it pushes the 3-day minimum for DWIs up to 6 days. And definitely something you want to try to avoid. So if you've enjoyed the video today, hit that like button, subscribe, ring the bell for notifications, do all that good stuff, and we'll see you next time. Thanks so much.